Yes, Mr. Tanner.
My lords, my lady, may I apologise in advance for two aspects of my oral presentation. The first thing is that I've developed a hearing problem in one ear. I'm unable to get an ENT appointment until Monday. And during the course of today, it seems to have developed further, so at least to me it sounds as if I'm gargling when I'm speaking. I've no idea how it sounds to everyone else, but
It sounds perfectly okay so far,
fine, but
Mr. Tanner.
if it doesn't for the hearing, if you may have to yell at me if you want me to hear something.
We'll do our best.
I heard Mr. Haynes perfectly well this morning.
Yes.
Turning then to the judgment, in general terms, what we say about the Deputy Judge's judgment is that it's very full, it is very careful, painstakingly so in terms of setting out the law, setting out the facts, and analysing the facts in accordance with the law as the judge has set it out and the authorities. And it addresses each and every relevant issue. Having said that, there's one very slight typo, I think, in the chronology, which in the judgment, which I'd better correct in case it makes any difference. It's paragraph 48. That's on page 67 of the bundle. And it says Spanish Social Services spoke to the mother by WhatsApp on 24th of September 2021. That should be August.
So sorry, which paragraph?
Paragraph 48. And if you want chapter and verse for that, you can find it at page 171 in the Social Services documentation.
24th August.
24th of August. It wouldn't make sense otherwise. In fact, the father went to the police in Spain on the 23rd, same day the children were removed from Spain. And he went to the social services in Spain the next day, the 24th of August. And the various entities in Spain contacted the entities in England, and the entities in England pursued the matter at this end. May I assume that the members of the court have read the preliminary points in paragraphs 1 to 15 of our skeleton for the father, in which we summarise the purpose and the nature of the 1980 Hague Convention.
Yes.
I know my Lord Justice Moylan will be more than familiar, but as my Lord has been said, it's a relatively new area of law for him. I'm afraid we reduction lawyers tend to talk in jargon sometimes, which can be a little bit off-putting. So please stop me if I start to do that. And we also in those paragraphs briefly summarise some of the relevant factual matters. I'll move on to the topic of consent, if I may, to start with, under Article 13A of the Hague Convention, given domestic effect by the 1985 Act. And then I'll deal specifically with the question of oral evidence within the topic of consent. First, the general principles as to consent and as to oral evidence apply in all cases in which those issues arise. So once those general principles have been ascertained, the question is as to the application of those general principles to the facts of each individual case. And the general principle that the deputy judge, identified as applicable to the consent exception is set out in paragraph 68 of his judgment, which is taken from the decision of this court in Ray G. And Mr. Haynes took you to that this morning.
Yes.
Ray G itself was informed by the earlier Court of Appeal decision in Ray PJ, and that PJ case is referenced in the Ray G decision, and the deputy judge had both of those authorities, amongst many other authorities, before him. But there's no dispute that those are the general principles as to consent. It seems to be common ground then that the deputy judge was applying the correct general principle in the sense of what had to be established by the mother, because the burden was on her, to make out the consent exception. And I dwell on that for a moment now, because that may have some relevance to the question of whether oral evidence was necessary to do justice in the particular case. So we need to look at what the real issue was about consent. Now, Mr. Hames, on several occasions this morning, said that the issue was, the disputed issue was, did the father withdraw his consent? And my Lord Justice Bean, we submit, correctly pulled him up about that characterisation of it, because we submit the question is not whether the father withdrew consent, because the original agreement, whether one calls it consent or not, was undoubtedly for the family as a whole to come to England. Whether one calls that conditional consent or whether one calls it on the basis of the family coming to England, but that was clearly no longer applicable once the father had no visa. So that part of the background falls by the wayside. What you're actually concerned about, and what the deputy judge was actually concerned about, was whether the father subsequently, despite that possibility of them going to England as a family having fallen by the wayside, whether nevertheless he clearly and unambiguously consented to the mother taking the children to England without him, and indeed on her case to live separately from him, because she said he was a coercive, abusive father. Although there's one passage I think we can find in the social services, the English social services documentation, where she was suggesting initially that the father might still be trying to come to England. But that soon changed into a, well, she'd in effect fled because of coercive and abusive behaviour alleged against him. So the actual alleged consent that one is looking at is, did the father consent to the mother bringing the children without him to England, albeit the previous arrangement had been for them to come as a family, and albeit they were living as a family in Spain, and albeit they were being visited and mentored a couple of times a week by the Spanish social services. And albeit, as soon as he discovered the mother had actually gone, he's straight off to the police station, and the next day off to the Spanish social services, who were themselves rather concerned to find that the mother had gone, and had gone alone with the children. We find all that in the papers. So that was what the deputy judge was looking at when he came to apply the relevant principles. And of those general principles, there are a few that we highlight in particular. First, the asserted consent must be clear and unambiguous and must relate to the situation in which the removal or retention actually occurred. And that's the point I've just made. Secondly, the asserted consent must not be qualified by or subject to a condition that's not met. Again, that's another way of putting the same thing, I suppose. Or obtained by a trick or by deception. And it must still be operative at the time of the actual removal or retention. An operative consent must be referable to the circumstances that were within the contemplation of both parties. Again, these are all ways of putting the same thing, I suppose. The assessment, says Ray G and Ray PJ, must be made in accordance with common sense and the realities of family life. I'll come back to the question of common sense in a moment. And the words and actions of the removing party may be relevant to the assessment of whether that party believed that relevant consent had been given in the context of the circumstances in which the removal had taken place, and that removing party believed that any relevant conditions had been met. So the words and actions of the removing party. So there we have a relevance of what the mother said when she first spoke to third parties about this, or to third parties in an official state, when she spoke to the English social services and when she spoke to the social services in Spain after the removal. Did she say, oh, I had the father's consent to come, and we're now living separately with his agreement, and we made all these arrangements for schooling and where the children are going to be living, and what future participation in the children's lives the father is going to have? Did she say that? No, she didn't. She said nothing at all about that. All she did was complain about matters of alleged coercive and abusive behaviour. So that point is relevant, about the words and actions of the removing party potentially being relevant to consent as well. And importantly, the burden of proof is on the party who asserts consent, in this case the mother. So having set out that general position, let me set out a summary of the way in which I put the father's case on this. In all cases that go to trial on the issue of consent, there will inevitably be a conflict of evidence between the parties on the documents. There wouldn't be a need for a trial if that wasn't the situation. That, however, the existence of a conflict of evidence on relevant points doesn't mean, in the context of summary Hague Convention proceedings, that a judge is always obliged to hear oral evidence in a consent case. Because if that was so, that would be the very antithesis of the assertions that, or the directions that oral evidence in all sorts of Hague Convention cases is only to be admitted rarely and sparingly. There is no such...
Is there a difference between rarely and sparingly?
Well, rarely, you should rarely have it. When you do have it, you should limit the scope of it, I suppose. But that's what the authorities say, that's what the guidance all says. Or is there some special rule for consent that doesn't exist in relation to matters relating to conflicts on habitual residence, conflicts on various other aspects? Article 13b is a special case that's been dealt with in a special way, special procedures being developed to cope with conflicts in Article 13b, and I'll come back to that. But I submit there's no special situation for consent cases. And the principle is that if the judge is satisfied that he can deal with the matter justly, and that's important, on the papers, given the context of summary proceedings, and given the burden of proof being on the person who's removed the children, and that person having had the opportunity to set out fully their case in their written evidence. And if you look at the history of this case, there have been 5 hearings the mother had certainly had the opportunity to gather her evidence and put forward her evidence on an informed basis, because the father's witness statement came first, and indeed the first evidence in the case was a witness statement from the father's solicitor. It's not been included in the bundle, but as those who do abduction will know, there's usually a statement from the solicitor for the applicant setting out the nature of the case as the solicitor has had it explained to them and received the instructions through the central authority. And it hadn't been felt necessary to include it in this case, but the mother had that. She had the father's actual witness statement before she came to prepare her case. So if the judge is satisfied he can deal with the matter justly on the papers, then that accords with the practice direction, the practice and management directive, and I submit it accords with some of the general principles that one can find in the authorities. So the question is whether the exercise the judge actually conducts then, can it be subject to interference as long as the judge approaches the case on that basis, as this judge did. One only needs to look at paragraph 12 of his judgment to see that was the principle that he guided himself by. And he said exactly the same thing in his supplemental judgment where permission to appeal was sought. Can one interfere with that exercise of discretion, that evaluative exercise, as I would seek to characterize it, and as it's referred to, a case management decision in some of the authorities? But it's certainly an evaluative exercise. There doesn't need to be oral evidence in every consent case where there is dispute on the papers, as long as I can deal with the case justly. He's adopted the correct principle. Has he erred in any way on the usual Wednesbury type grounds, as I'll call them? Has he failed to deal with something? Has he taken something inappropriate into account? Is it a decision that no judge could reasonably have come to in those circumstances? Albeit another judge may have said, all right, I'll hear some short evidence. It doesn't follow that an appellate court is entitled to interfere with that aspect of the trial judge's role, as long as he hasn't erred in one of those ways in that evaluative exercise of can I deal with the case justly on the papers. And if the judge determines that on the material the consent defence is so inconsistent with common sense and with other material, other indisputable material, and so improbable that it's not necessary to hear oral evidence, who can gainsay that that was a perfectly proper exercise of his evaluative rights, even whether another judge might have said, all right, let's have some short oral evidence about it. And that's even without coming to the question of what you want oral evidence of, bearing in mind that the mother's case should have been set out fully on her witness statement, because that's what happens in Hague Convention cases as in every other civil case. Mr. Hames
Isn't that rather putting the cart before the horse, Mr. Turner? Because if the judge has made his or her mind up that the evidence of one of the parties is so inconsistent with common sense and so improbable that they don't need to hear from them, they've effectively come up with an answer to the question before deciding whether or not to hear the oral evidence. Can't be right.
Well, he's come up with the answer as to whether he can hear the case justly. But I accept my lady's point that he has, in a sense, because he's looking at the same factors. So I acknowledge.
I can well see that you could make the submission that, for example, you may have a case where there is an overwhelming body of documentary evidence that points in favour of X, and no documentary evidence the other way, or that there may be documentary evidence going both ways, contemporaneous. and the judge says, well, I'm not going to be advantaged by hearing from the parties. I can make up my own mind on the documents. That's not this case. There were no documents.
But if there is no principle that there must always be oral evidence permitted in consent cases, that there's some special breed of matters, albeit a summary process, then by what criteria is a judge to decide whether it's necessary to hear oral evidence to decide the case justly?
Well, what my lady has identified is that in this case there is an absence. It was referred to, there are no text messages, no WhatsApp, no emails, as is not uncommon in Hague abduction cases. But there's a complete absence of documentary evidence directed specifically to the issue of consent. But you've referred to the judge's supplementary reasons on page 90 of the bundle. During the course of those, he says that he refused to order oral evidence because he considered that he had sufficient documentary evidence. What was he referring to?
Lord, he was referring, I would submit, to, first of all, the evidence that had been produced at the request of the court. There were two directions hearings where the court requested evidence from the Spanish and the English social services. There was the father's evidence and the mother's evidence. And in particular, there was the undisputed evidence that the father had gone off to the police straight away after he discovered the mother had gone, which the mother addressed simply by saying, oh, well, he must have changed his mind, which we would submit is so improbable that a judge is entitled to say, I don't need to hear oral evidence. Doesn't have to say, I won't hear oral evidence. Is entitled to say that. But there's the problem. If there's not some rule or principle that oral evidence is permitted on request in every consent case, then which are the cases where it's not required? And we can find, by looking at the authorities, cases where judges have refused it. Mr Justice MacDonald, for example, Mr Justice Peel. The Mr Justice Mostyn case that gets a lot of publicity, as it were, isn't a consent case at all. It's about generalities. But we know other judges have said, well, I then reluctantly agreed to hear oral evidence. And in fact, it made no difference to the common sense answer that was staring me in the face from the papers. And one does have to bear in mind that the burden is on the person who's removed the children. So has she, on the face of the papers, even begun to deal with that? Is there any area that needs to be further explained? How is it going to be explained? Who is going to do the explaining?
Well, isn't the touchstone fairness? Because it may well be that in 99.9% of the cases, the common sense approach is not changed by hearing oral evidence. But there may well be, in that 0.1 case, a situation where, being faced with an explanation, the judge says, actually, it looked as if it was all stacked in one direction, but I'm persuaded on the balance of probabilities it isn't.
So where is the judge going to get that material from? Because if it's to come from the mother, using the parties in the present case, if it's to come from the mother, why isn't it set out in her written evidence? And if the answer to that is, oh, well, you've got to see her and judge her demeanour, well, that runs into all the familiar problems about judging witnesses on the basis of demeanour. If it's to come from cross-examination of the father, in the present case, how was that going to help anyone when cross-examination would have to have been, number one, through an interpreter and by a video link as well? But we come back to the point that there is a power to hear oral evidence. There's a power to refuse oral evidence. It's a matter of discretion. And like all other judicial discretions, it's got to be exercised in a principled way. And people tend to call it an evaluative exercise now rather than an exercise of a discretion, but they mean the same thing. But can it be said that this exercise was so off the wall that it should be interfered with by this court? And if so, then how does one judge at first instance when those rare cases that oral evidence is permissible, and when is the generality a case when oral evidence isn't permissible?
Well, if we can then, on the back of that submission, look at paragraph 10 of the judgment.
Yes.
Where the judge refers to ES and LS and refers to re-IK and the decision of Mr Justice McDonald just mentioned. And what he draws, or appears to draw from those cases, is proceedings as summary, oral evidence is very much the exception rather than the rule. Then he observed, that must be Mr Justice Mostyn, that there was no obvious reason why Article 13b defences should not include oral evidence, but defences of consent and acquiescence should be heard with oral evidence. So, and he then observes that Mr Justice Peel agreed with those views. So that's the context that the judge set out in his judgment for his assessment, along with the...
Well, rather more importantly, paragraph 12, of course.
No, I see that, but that's the context.
Yeah.
And you, in your written submissions, have identified why there is a difference between...
The fallacy of the Article 13b comparison.
Exactly. That is a fallacy.
Yeah. Well,
among other things.
Quite gently, but it is.
It is, because defences of consent and acquiescence are facts that have to be proved. Whereas Article 13b, as you say, is based on...
You've got the procedure for
Exactly.
taking it at its highest and then seeing
So,
if they're... So you're not comparing like with like.
You would not seek to support what the judge set out in paragraph 10.
I wouldn't seek to support what Mr Justice Mostyn and other judges have said comparing Article 13b cases where there is no oral evidence with other cases. But I nevertheless seek to support the general proposition that appears in those cases that oral evidence is rare in all sorts of Hague Convention situations, and whatever the particular issue, it's dealt with in a different way, as I say, in Article 13b.
Yes, but I mean, as identified in part by Mr Setright, Lord Justice Thorpe a long time ago said the classic case, I think we're not sure those exact words, but the classic case in which oral evidence will be permitted is, he thought, less so acquiescence, but was consent.
Yes, that's the Ray F case, but he didn't go so far as to say it must be permitted.
No,
far from it.
Absolutely. But where do we see in the judgment the judge's recognition that oral evidence is not uncommon in consent cases, more likely to be appropriate in consent cases because of the factual issues?
Well, because if you said,
particularly in the absence of written
if you said that,
evidence.
You'd be departing from the principle that each case must be decided on its own particular facts.
Yeah, but we're dealing
It
with
doesn't
consent.
actually matter
We're just
whether-
dealing with consent.
It doesn't actually, no, even with consent, it doesn't actually matter whether in consent cases they usually are. Indeed, you only have to read Mr Justice Mostyn and some of the other judgments to find that in consent cases there had grown up a practice that there will always be oral evidence upon request. And we submit that that's as wrong as saying that there must never be a blanket permission and a blanket refusal.
Well, practices don't grow up for no good reason, Mr Turner. Practices grow up because there's some foundation for it. And as my Lord has already put to you, the distinction in kind is that this is a fact-finding exercise, albeit truncated because of the exigencies of timing and so forth. And surely the acid test is This is a fact-finding exercise. Can I fairly determine a question of fact against X or Y without hearing from X or Y? If it's one of those cases where it is fair, because you've got a preponderance of documentary evidence and what is going to be said by X or Y wouldn't make a jot of difference to it, then the answer may well be you don't have oral evidence. In the absence of that, you do.
Well, lady, I say that this is one of those cases where the judge was entitled to find that common sense, on an analysis of the documentation and evidence that he did have before him, made it so improbable that the father had given consent in the way the mother asserted, without there having been any discussion about things such as schooling, where she was going to live, and we know she's moved from pillar to post in England with the children since she's been here, about such things as what role the father is to have in their lives. That, I submit, is so improbable that as a matter of common sense, the judge, in the exercise of his discretion, bearing in mind that it's a summary process, bearing in mind that the burden of proof is on the mother, is entitled to say, I don't need to hear oral evidence about this. It's clear from the documentation. The father going off to the police the next day, it just doesn't begin to answer that by saying, oh, well, he must have changed his mind between, as it were, was waving us off and then trotting off to the police station once we'd landed.
I'm not sure that I got your answer, forgive me for this, to my lady's question. Doesn't that rather put the cart before the horse? In other words, you're determining the probabilities for the purposes of deciding whether to hear oral evidence.
Well, you, in a sense, you are, but that's permissible in this context, in my submission, which I think I did say, but I probably didn't say it clearly.
So you're saying you're entitled to evaluate the... You're
entitled to evaluate the written evidence, because in order to be able to say, and I submit that the tests were see from various of the authorities, improbability and common sense are factors that one's entitled to take into account.
So it's really the written evidence and the strength of the case.
Yes.
For the purposes of deciding oral evidence.
And bearing in mind the nature of the process. And there's one thing I disagree with on behalf of the father. I think it's somewhere in Mr Setright's submissions, where he talks about the consequences of getting it wrong being rather more serious than Article 13b. Well, and I've probably misrepresented what he said, but if that be said, it's not right. Because with Article 13b, unless you get that right, you're sending a child back to face an intolerable situation. With a consent case, you're simply sending a child back for the court of habitual residence to deal with the matter on a fully informed basis. So that's what I mean when I talk about the context of the case being a summary process.
And the other question I had is this an extrapolation, or does the judge actually say anywhere, I didn't hear all evidence because I thought the mother's case was so improbable and I didn't think I needed to? Does he say that in his judgment?
No, I accept he doesn't say anywhere in his judgment. He doesn't set out in his judgment. I wasn't there, so I didn't hear any earlier judgment on the extempore judgment.
Well, I think we were told that what was in here was a reasonably accurate summary of what he said in his extempore judgment.
But I accept he doesn't actually set out any reasoning in paper as to why he doesn't need to hear it. So in that sense, I'm seeking to extrapolate, as your lordship rightly says.
Another way of describing it, sorry, this is slightly pejorative, is filling in the gaps.
Well, Your Lordship has my submissions on it. We still don't know in which situations. I mean, you have those cases where there is an issue that arises under Article 13b that can't be dealt with by protective measures. And it's the relatively common situation where the abducting parent of a young child who's never been away from that parent says, well, I don't care what you order, I'm not going back with the child. The focus is on the child, and you have to say, well, would it create an intolerable situation for the child to be returned without that parent? There are some cases where the court says, well, it won't be an ideal situation, but the father can perfectly well look after the child or children. But there are other cases where it's crucial.
That was Mr Justice Holman case that we saw this morning.
Yeah. And the first of those cases you were taken to this morning, or referred to this morning, was the Ray C case, where it was Mr Justice Cohen, I think, at first instance, who'd declined to hear oral evidence on the question of the mother's state of mind. Now, if ever there was a situation where one might have thought it's difficult to evaluate on the basis of a paper exercise, it's looking at someone's state of mind, an emotional state. But Mr. Justice Cohen refused, in the exercise of his discretion or case management powers, to hear such evidence. The Court of Appeal upheld his decision. You then have in contrast the case that I did last November against Mr. Hames in front of Mr. Justice Holman, where Mr. Justice Holman decided, having looked at the Ray C case, decided that in our case it was proper to hear the mother. And number one, hear her explain it for herself, her state of mind, and hear how she presented that. And secondly, to hear her evidence tested on the anvil of Mr. Hames' cross-examination, as Mr. Justice Holman put it. So that shows the breadth of the discretion that exists in a situation where one might have thought that it was far more difficult than in the consent case to make a decision on the papers as to whether the mother would return without the child or whether she wouldn't. So whether Mr. Justice Cohen was right, whether Mr. Justice Holman was right, it's a discretion. And unless you can say that no judge could properly have reached that determination, and as long as they apply the appropriate principles, then it's not something that the appellate court can properly interfere with. And I've referred in my skeleton argument to what the Supreme Court said in Ray S, mirroring what the House of Lords, I think it was before that, said in a case called Ray J about courts overturning exercise of discretion in child abduction cases. And I've set out the references to both of those in our written presentation. So I say really it's a question of what's the judge entitled to, but that question of whether oral evidence should be permitted, and if so, in what circumstances, has been addressed in the authorities in the context of various issues that arise under the 1980 Hague Convention. And can I just pause there to go back to Ray E? Let me just have a look at that. It's tab 9 in the original bundle of authorities, I think. And it's paragraph 36. Having been pointed out that hearing oral evidence conflicted with the concept of a summary process, but on the other hand, the dangers of sending a child back to an intolerable situation, how could you deal with that? And at paragraph 36, to which you've already been referred, it's in the authority, it's page 161, in the bundling numbering, it's page 188. There's obviously a tension between the inability of the court to resolve factual disputes between the parties and the risks that the child will face if the allegations are in fact true. Not the same as in a consent case, not the same anxiety. Mr. Turner submits there is a sensible and pragmatic solution, but as I've acknowledged, that, I hope it was a sensible and pragmatic solution, only applies in Article 13b cases where you can take the allegations at their highest. You can't take an assertion of consent at its highest and then look to see if there are protective measures. And then the court says, right at the end of that paragraph, without such protective measures, the court may have no option but to do the best it can to resolve the disputed issues. What it doesn't say is the court must then hear oral evidence. The court must do the best it can. And my recollection is, and Mr. Setright will correct me if he's got a recollection about it, is the Supreme Court had been regaled with all those authorities, such as Ray F., about how one deals with oral evidence if there is a conflict on the evidence that may be determinative of the outcome of the case. But the court didn't then say, well, if there's a conflict that's determinative of the case, you must hear oral evidence. It's a much more generalised, you must do the best you can. And that was in the context of knowing what the arguments were about that.
If I may say so, Mr. Turner, I think you're right in saying the unexpressed basis of the judge's decision on this heading is
Sorry, Lord.
the unexpressed basis of the judge's conclusion on this issue is, I consider that the mother's case is so improbable that she should not, that there should be no need for her to be cross-examined. I simply reject it, as it were, on the papers. And the question is whether that's a permissible approach.
Yes. I accept and concede that if he'd said that, it would have been better.
Yes.
But one can legitimately extrapolate and look at the end result to see that the judge did say that on the papers it was inconsistent with common sense, and it was so unlikely as to be, or so improbable as to be vanishingly likely. Bearing in mind again, as I say, the context, the summary disposal, and the burden of proof being on the mother, then, and the other evidence and material in the case, then nobody was ever going to find whatever the mother might be permitted to say in further evidence in chief, whatever one might get from the father in cross-examination, in the real likelihood is the mother's case will crumble even further under cross-examination in my submission. If this court sends the matter back, then that will happen, but there'll be more delay at that stage, and we know that delay is dangerous because delay can create its own Article 13b situation, even though one may not have existed in the first place. But the judge purports to have applied the principle that he expressed in paragraph 12 that came from the practice guidance and paragraph 4 of the supplemental judgment. That, I submit, was the correct principle. only if it's necessary, and it can't be necessary in every case where there's a conflict. What is clear is that the judge didn't approach the case on the basis of some sort of blanket ban on oral evidence, just as I submit it would be wrong for a judge to say, oh, well, it's become the custom to allow oral evidence in these cases. You run into the danger, if you do that, that's explained in one of the Irish cases that Mr Setright refers to. The court have Mr Setright's skeleton argument.
Paragraph 16.
Yes, indeed. Paragraph 16. Internal page 11 of his skeleton argument, paragraph 16. Of course, all of these cases that Mr Setright's referred to in this section of his skeleton argument are helpful because they give you the international perspective, and it's a broad perspective. Some countries just won't permit any oral evidence. Some permit it, or will always permit it. Some permit it on a discretionary basis. There is no one-size-fits-all, although, of course, since we're all applying the same convention, one would hope that there'd been consistency in approach. But as in so many things under the 1980 Hague Convention, there isn't consistency in approach. But the Irish Court of Appeal, paragraph 61 of the extract of the judgment that Mr Setright has set out, about 4 lines down, said, however, it's clear that where there are irreconcilable differences emerging between the parties on the affidavit evidence pertaining to matters of crucial importance, which are not otherwise capable of resolution without the hearing of oral evidence, then if the court considers it necessary, not, well, the court must consider it necessary in that situation, but if the court considers it necessary to do so and remains otherwise unable to resolve the issue, the trial judge is entitled in her discretion, contrary to the normal convention, to hear oral evidence. And I turn over page to paragraph 81 in the extract from that judgment. The proposition advanced at the hearing of this appeal on behalf of the mother that oral evidence would have resolved matters is wholly fanciful, insofar as inevitably, in the light of the affidavits, there would simply have been a swearing match, or as I'd put it, a, oh yes you did, oh no you didn't, sort of standoff situation in our case, between the parents as to whether the purported signature was the father's or not, or here, as to whether the father said, oh, even though I can't go with you as a family, and even though you're going to separate from me, and even though there are no arrangements about my future participation in the children's lives, even though there are no arrangements about where you're going to live or where the children are going to be educated or any of those things, even though the social services in Spain haven't been notified, the mother will say, oh, you did agree. And he'll say, oh, no, I didn't, insofar as one can work out what he's saying at all from what comes through in the translation over a remote link. So it would serve no useful purpose. And I accept again that the judge didn't set out in terms that as reasoning. But equally, he didn't say as a blanket ban. He said when necessary. And those authorities that he referred to in paragraph 10, not one of those, if we look at them, says there should be a blanket ban on consent, on oral evidence in consent, or on anything else. What they actually do is point out the rarity of situations where there should be oral evidence. And in one case where oral evidence had been heard, well, my initial instincts were right, it made absolutely no difference to the output. So what does the published guidance and what do the authorities say? Can we just have a quick look at the published guidance and a few more of those authorities? The Guide to Good Practice published by the Hague Conference is in the Supplemental Authorities Bundle, which has been produced to the court this morning. And it's at tab 1. And it's page, I think we need page, Mr. Setwright has quoted it in any event in his skeleton. It's paragraph 6.5.2, it's internal page 35, printed page, bundle page 54. Starts off at the top of the page. Courts in a number of countries normally decide on request to return to them on the basis only of the application and any documents or statements in writing submitted by the parties without taking oral testimony or requiring the presence of the parties in person. Well, does that mean they're not doing justice in some cases?
Sorry, I lost the. Where are we?
Sorry, in this morning's the supplemental bundle. Internal page 50. Oh, internal page 52. Sorry, it's. I think the numbering doesn't include.
Of course, it's 6.5.
It's internal page 35
Yeah,
of the document.
thank you.
Yes.
Probably printed numbering 52 on the bottom. And then 2 paragraphs on, Hague return cases lend themselves to determination by summary proceedings. A full trial consisting of an evidentiary hearing will normally not be necessary or desirable. And I've pointed out again that you can have your full trial on any issue in the home court where it should have taken place anyway. It's more dangerous where you've an Article 13b situation and you're returning someone who might be a child who may be placed in an intolerable situation, and that's why there was a particular concern there. But in relation to matters such as consent to removal, the mother can apply to the home court to remove the child and can say, well, look, he agreed, now he's going back on it. Why did he agree? Why has he gone back on it? That can all be determined perfectly well in the home court. So in a summary process, there's no necessity to deal with that. And then towards the bottom of the page, much may depend on the issue. For example, in some jurisdictions, oral evidence is more likely to be admitted if there is conflicting documentary evidence by the parties which cannot be resolved without cross-examination or oral evidence. If that's the case, as a general matter, both parties should be given the chance to be heard. Over leaf, the first paragraph at the top of the page, the end of the first segment of that, in many systems, the individual judge trying the case has a degree of discretion. And that's what I submit is the situation in this jurisdiction. We then have the practice guidance, which the judge referred to in paragraph 12, but it might be quite useful to actually look at that, the particular passage in full. It starts on, I think you all have it on printed page number 86, although we've got it on electronic page 88. It's under the heading Case Management. So it's regarded for these purposes as a case management matter. Does the court have that? And then its overleaf one finds the substantive part about oral evidence at paragraph 3.8. The court will rarely make a direction for oral evidence to be given. Any party seeking such a direction for oral evidence will need to demonstrate to the satisfaction of the court that oral evidence is necessary. Now I pause there to say that there's a point there to be made about burden in establishing that oral evidence is necessary. So any party seeking such a direction will need to demonstrate to the satisfaction of the court that oral evidence is necessary to assist the court to resolve the proceedings justly. Any party seeking to rely on oral evidence should raise the issue at the earliest available opportunity and no later than the pre-hearing review. But that's the full extract. And then the authorities. You've already been referred to Ray F. It's in that same supplemental sorry, no, it's not. It's tab 8 in the supplemental bundle.
Yes.
One can look just at the head note, just a case about acquiescence. The judge should have heard oral evidence to resolve that major conflict of evidence. In fact, it was determined ultimately on the basis that no one had asked the judge to, so how can he be criticised for not doing it? Although in itself that may mean that the case hasn't been fully determined in accordance with the merits. But we've got held the sparing use, summary in nature, speedy resolution. If a judge is faced with irreconcilable affidavit evidence on crucial issues and no oral evidence was available or no application made to call it, and to look to see if there's independent extraneous evidence. Alternatively, so we've got alternatively to all that comes before, the evidence contained in the affidavit might be so inherently improbable that the judge was entitled to reject it. If there were no grounds for rejecting the written evidence on either side, the applicant would have failed to establish the case. So that's where I get my proposition that the judge is entitled to look at inherent improbability. And Ray G, one's looking at common sense in all matters concerning consent. The recent case by Mr Justice Holman, well, I'm not going to take you to that. You've got that supplemental authorities at tab 9. I've already explained that. And I've explained how it reaches a very different decision from the very similar case of Ray C. Incidentally, if we look at Ray C, because that's relied on by my learned friends as the president, Sir Andrew McFarlane, approving the permitting of oral evidence in certain cases, although upholding the refusal in this case, I submit that's just not borne out by what's said. And the relevant passage is in the original bundle of authorities, at tab 4, and I think it's paragraph 59. I bear in mind, I think that my Lord Justice Moylan agreed with this. 59. On the question of whether the judge fell into error by not requiring the mother to give oral evidence, it's clear there's no report authority on the point in this context. Hague Convention proceedings are summary, and save where it's necessary to do so, on issues of consent or on issues of habitual residence or consent and acquiescence, oral evidence is not adduced. Well, that's not saying it is necessary in cases of consent or habitual residence. It's saying that where it's necessary in cases of consent or habitual residence. And if it's necessary in those sort of cases, why isn't it necessary when you're determining the state of an abducting parent's mind who says, I can't bring myself to return with this child, and that's a genuine state of mind? How can you judge that, other than thrashing it out on the anvil of cross-examination and forming an assessment of that party? And as I say, yes, my Lord agreed with that judgment. We have Mr. Setright's skeleton argument. Let me go back to that. Helpful as ever, of course. In paragraph 10, he refers to Ray K. Again, no mandatory blanket ban or no mandatory automatic permission. Simply said their consent is a classic area where evidence will be permitted, not that it's always necessary to permit it. Depends on the particular facts of the individual case and the material in the individual case. And then Mr. Setright's skeleton goes on to identify, as I've said, the various practices as to oral evidence in other countries. And I've already drawn attention to the Irish case. And we draw attention also in particular to what Mr. Setright says, paragraph 19. And this is his submissions, of course, not cases, although taken from authorities and practices. Statements of the past are treated as their sworn evidence. You don't say, well, I think I'll top that up a bit now I've had a further think about any more than you would in any other area of law. Statement stands as evidence in chief, and the court can control whether or not cross-examination is permitted. It's possible in appropriate cases to fact-find or otherwise resolve disputes on written evidence, especially, for example, where one account is corroborated, and we submit that one account is corroborated by those matters of common sense and improbability that I've already highlighted, and which the judge went on to highlight, but the other is not, or where one account is contextually inherently incredible and the other contextually inherently incredible. I've got the other way around, but so in a sense, Mr. Setright is making the very points that I've been making. However, where there is a narrow balance, or even a complete balance on the written accounts, or where there are gaps that manifestly militate against determination of a relevant issue on the material that stands, oral evidence may be the best or the only way. Well, that's not this case. And paragraph 21, Mr. Setright qualifies by where it is necessary, where it's balanced, and there's no supporting material one way or the other. But this isn't one of those evenly balanced cases. And paragraph 26A in Mr Setright's skeleton. Right at the end of 26A, no absolute rule can be imposed applicable to all cases that oral evidence must be heard and or must never be heard. And we submit that that's absolutely right. Shall we take a quick look at what Mr Justice Mostyn, Mr Justice Peel and Mr Justice MacDonald have said in recent times, bearing in mind...
I wonder, Mr Turner, again I'm looking at the
I
clock,
see, yeah,
and we have got the references to what Mr
Right.
Justice Mostyn and Mr Justice Peel said and so on. And probably you don't want to
No,
let
I take your
13B
lordship's
go
point.
by default, so we probably ought to wrap up quite soon on 13A.
So I do refer to those and what they say. As a matter of principle, there should rarely be oral evidence on any matter, one of those matters being consent, although the Mr Justice Mostyn case wasn't consent, and he did, in my very respectful submission, illegitimately compare 13B cases with other cases, but that doesn't cause any departure from the general principle that oral evidence should be rare. As I've said, Article 13B is a special case for other reasons, because of the dangers of sending a child back where it would face an intolerable situation. As the House of Lords said on the old cases Ray D, although theoretically there's a discretion that arises once you've satisfied the gateway requirements of intolerability, it would be an odd court that exercised the discretion in sending a child back once it found that it would face an intolerable situation.
Yes.
So, was it, as I say, an exercise of discretion no judge could properly have reached? I've referred already to what's in paragraph 35 of Ray S about illegitimate interference with exercises of discretion that are conferred on trial judges. And then I asked, what would oral evidence have achieved? Compare with the Irish case again. No indication of what the nature of any oral evidence would have been, or at least not until Mr Haynes stood up and said a few things. I don't know how it was put to the judge below. The first paragraph of the grounds of appeal simply refer to exploration by way of oral evidence. So the potentially relevant matters were simply the competing contentions about whether the father had been aware in advance of what the mother intended to do at the time when she did it and consented to it either by necessary implication or in fact. And we've already been through why that is so improbable, and the judge went on in his subsequent judgment to explain in detail why it was so improbable. Let me just turn finally on 13A to the actual grounds of appeal. Does the court have the grounds of appeal? They're all sub-grounds within ground one. And it's suggested there that it was necessary to hear oral evidence to judge the credibility of each party. Well, I've already addressed the question of credibility, demeanour.
You have.
B, it said that the listing of the case wouldn't have been disrupted. There was sufficient time allowed to enable brief oral evidence to be taken. Well, begs the question of what oral evidence, but that doesn't affect the question of principle. If it can be done in short order rather than long order, it doesn't justify doing something just because of that. C, it says excessive weight was given to the views espoused by Mostyn and Peel J. Well, grounds of appeal that argue excessive weight, I always submit, are inappropriate grounds of appeal because one doesn't know what weight, if any, a judge gave to a particular matter. But in any event, I say that save for the Article 13b point, what Mr Justice Mostyn, Mr Justice Peel and Mr Justice MacDonald said was absolutely correct. And Mr Justice MacDonald has been entitled to refuse to hear oral evidence on the consent issue in his case. And then finally D, wrong to disregard the accepted practice of hearing oral evidence. Well, if there is an accepted practice of always hearing oral evidence, I say that's wrong. As Mr Justice Mostyn had said about certain things, well, it had been argued before him that where there was, I think it was to do with a court welfare officer, wasn't it? That as far as it was said there was an accepted practice, there isn't. You've got to deal with it on the facts of the particular case. And D also refers to what the President said in the case of C that we've just looked at, which itself upheld the non-giving of oral evidence in a case that concerns someone's state of mind. So that's, I think, all I want to say about the Article 13a point. Can't be said the judge either erred in principle, and it can't be said he exercised his discretion in a way that permits interference. If I'm wrong on that, then as Mr Hames has submitted, there would have to be a rehearing, unless, of course, the appeals allowed on Article 13b as well, and in some way the court didn't determine there had to be a rehearing on that too, but it's difficult to see how that could be the situation. So let me turn then to Article 13b.
Yes.
And a lot of what I'm going to say about that is simply referring to what the judge said and saying we support what he said about that. So in relation to Article 13b, I repeat what I've said in writing previously about the nature and purpose of the proceedings under the Hague Convention. They're important. The burden of proof, again, is on the abductor who didn't get permission before passing go. Importantly again, Article 13b doesn't create a welfare or best interest test, and if you apply too high a threshold, you will undermine the purposes of the convention. Intolerable situation, not the same thing as an imperfect situation or an unsatisfactory situation. And indeed, in the present case, the situation for the children in England might be thought to be every bit as imperfect and unsatisfactory as it is argued that it would be in Spain, although we don't accept that it would be imperfect in Spain. The wording of the convention, the authorities are peppered with references, the need for applications to be dealt with promptly, and I say that by reference to the assertion or the argument that there should be further investigation. The orders that were made in this case on the 5 separate hearings can be found in the supplemental proceedings bundle. And you can see that there were various directions given for material to be obtained from Spain and English social services as it was. And it's quite important to look at that material. And I'll take the court to some of it in a moment briefly. What more could be obtained? And we know how Article 13b is dealt with. Take the allegations at their highest. Look to see if there are any protective measures available. Protective measures meaning either entities, institutions, laws, or whatever that are available in the overseas country, or undertakings that are given by the other party. And here, the father had to satisfy conditions precedent in relation to some matters, which are still complained about, and in others he gave undertakings which are enforceable under the 1996 Hague Convention. The Lord looks quizzical.
Yes, I think that's quite a difficult issue.
Well, the Court of Appeal has said undertaking, the case of Ray Y.
I know, a long time ago, and I think matters have developed since then. And in particular respect to Article 11, I find it difficult to see how a protective measure can be within the scope of Article 11, and it's not a measure that's within the scope of the 1996 Convention at all, such as maintenance. Well, so I'm just saying it's a broad issue.
Yeah. Well, my Lord, at the moment, the authority of this court, in the case of Ray Y, and I'm afraid we don't have it in the bundle because I didn't foresee it was going to be in any way contentious, because this court is, I submit, bound by its previous decisions, is that such matters are enforceable under the 1996 Convention.
I just raise a question anyway. You make the general submission that the protective measures can include a wide range of matters, which can include undertakings.
But then one has to distinguish between, as it were, soft landing matters and matters which, if they're not in place, would create a situation that would otherwise be intolerable for the children. There's an interesting question that's never been determined really about, is it tolerable for children to have to go back when one parent has abducted them, even though that may create all sorts of unfortunate situations? Is it tolerable in the circumstances? But again, that's unresolved at the moment. I take you to paragraph 36 of Ray E. The various subsequent first instance and appellate cases, lots of them the judge was referred to. He was well aware of the two-stage test, and I can just give you the cross-references for where he directed himself about that. Paragraph 70, 47, brackets 4. Well, 70 contains a quotation from another case, and it was within the quotation 47.4, and similarly in that case 47.7, and then various other places, including paragraph 113. The judge also directed himself about there needing to be concrete satisfaction. For example, paragraphs 73 and 121. What the judge certainly did, before I come to that, the court is also entitled to bear in mind, when looking at protective measures, that there is a presumption of English law and I've dealt with this fully in our position state, our skeleton argument at paragraph 43 onwards, stopgap protection, presumption of English law that overseas law is the same as English law unless and until the contrary is proved. It's Ray J, House of Lords, Mansour and Mansour, Court of Appeal, then Master of the Rolls. Wasn't a family case, but strangely reported in the family law reports. And then similarly, there are any number of cases, some of them quoted in our 43 or cited in our paragraph 43.2, sorry, 43.3, where the court should accept that unless the contrary is proved, the administrative, judicial and social services authorities of the requesting state are equally as adept in protecting children as they are in the requesting state. And one of those cases, the last of those, is Riel, which was the Mr Justice Wilson, as he then was, dealing with risks of an abducting parent being arrested and prosecuted. And paraphrasing what he said there was that we must rely on our fellow signatories to the convention to do the right thing, bearing in mind the interests of children who may be affected, and bearing in mind in this country, in a particularly grave case, we do prosecute child abductions, although when it comes to sentence, the courts will take account of any responsibilities towards children. But since it's a condition precedent anyway for the father to produce evidence that he's withdrawn his denunciation, his criminal complaint, in a sense that goes by the board. But it may be quite useful to just look at what the Spanish social services have done by way of assistance in the past. Can I just take you to the core bundle? And the first is page 173. And this is a passage that's quoted by the judge. The sort of support that has been given to this family in the past, no reason why it wouldn't be given on a continuing basis, and indeed it's been said they would be allocated the same social worker if they went back to the same area. And it includes assistance in obtaining residence permits. And turning over leaf to 174, segment 4, section 4, see again the sort of support that's available. Section 5.
The mother and the children don't actually have residence.
I'm sorry, my lord?
The mother and the children do not actually have, to adopt that language, residence permits.
No, they don't. Well, as far as I'm aware, they don't have residence permits. But remembering that this is a stopgap jurisdiction, and bearing in mind that on any view of things, they're entitled to go to Spain for 90 days, and bearing in mind they are entitled, as in all other matters relating to stopgap provisions, such as provision of finances, they're entitled to approach the courts in Spain. The mother could make an application for relocation in Spain.
Where's the evidence of that?
Sorry, my lord.
Where's the evidence of that?
Why?
There's no evidence, Mr Turner, of anything that the Spanish authorities could do in relation to giving residency to mother or the children.
Well, I've just referred, first of all, to paragraph 173, the social services assisting in that regard.
Right, but that doesn't help, does it? They can give all the assistance in the world,
Yeah.
but if there's no legal entitlement to it, you don't get it.
If there is no legal entitlement, my next point was the mother can approach the courts in Spain for permission to relocate to England with the children. And if that's in the children's best interest, bearing in mind that Spanish law is presumed to be the same as English law, and unless and until it's proved to the contrary and any burden of proof is on the mother, then the stopgap gives the mother the entitlement to do what she should have done in the first place in seeking permission to relocate before she took the law into her own hands. That's 173, 174, 175. It's quite apparent from all that the social services, the authorities in Spain had been funding this family while it was in Spain. But once the children have gone, the father's funding stops. We find that on page 175. And then 198. We have further information provided at the request of the High Court from Spain. We see under section 2, paragraph, regarding whether the family or its members return to Spain, if they return to the municipality of Alicante, they'll be assigned the same social worker with the same team of professionals from the social services to assist them. If the return were to any other municipality, they could attach it there. But again, we've got the presumption that the authorities in Spain will look out for these children in exactly the same way as social services in England are looking out for them. And if that's not the situation, then the burden of proof is on the mother to establish that. And that's where I submit sometimes people rely on the P authority, or GP as it's sometimes reported, or reported in some places, the concrete evidence one, to suggest that some general inquisitorial process goes on here in relation to protective measures. What it is protective measures will be identified, and if it's said they are insufficient or not available, then the burden is on the person asserting that to establish that. But the judge did look at it in concrete terms, I submit, as one can foresee. I won't take you through all the various other social services material that's been obtained, but I do invite careful consideration of what's said in the social services material. One can also find, I think it's page 225, that it was the actual social worker who said what the mother had told her. Just turn that up, 225. Yes, the Spanish social worker has been clear that the children will return to the care of parents in Spain based on an assessment that Mr. Benedou was the protective parent in the relationship. But that's really by the by, unless it's suggested that they'll live with him. And there's no suggestion of that. He's agreeable to undertake to have nothing to do with them other than permitted by the court in Spain. And the court in Spain will undoubtedly have the ability to either make appropriate orders in that regard or to enforce undertakings in that regard. Now, what we say is that the judge, in this case, in paragraph 112, accurately identified the matters of alleged concern, alleged to amount to Article 13b situations, and he then went on to address each of those 5 matters, having directed himself as well in paragraph 113 that he had to bear in mind effectively the Ray E approach. And he started with physical and emotional abuse. But of course that's disputed that there was physical or emotional abuse. The judge addresses that, identifies what's alleged in that regard, identifies the mother's case in that regard and the denials about that. In paragraph 121, he has to consider in concrete terms the situation would face the children. And in taking the allegation at the highest, I don't consider they reach the high test of grave risk required for Article 13b. In reaching that conclusion, I bear in mind, and he sets out matters which can effectively be described as, well, if and insofar as the mother's allegations are true or valid, they can be addressed by protective measures. And that's
If you go back then to the second sentence of paragraph 121.
121, yes.
121. In taking the allegations at their highest, they do not consider they reach the high test of grave risk. Which part of the re-E approach is he there addressing?
He's conflated the two stages, I accept. But I also submit there's actually nothing wrong with that. As a matter of principle, what's the difference between saying there are disputed allegations of physical and emotional abuse? If they did happen, which is denied, then the petition for the future can be safeguarded in certain ways. Now, why, as a matter of principle, is it not permissible to deal with that compendiously rather than say, well, I accept that if those matters are true, a return to that situation, which is not what's suggested anyway, because they wouldn't be returning to the father, would be an intolerable situation. And now I go on to ask whether that can be ameliorated. What I ask rhetorically is wrong in principle with conflating those two, as long as, if which is not admitted, there is no danger. Now, reference.
Good job it's a rhetorical question, because I could give you any number of answers to it, Mr Turner, but that will just prolong an already long afternoon.
Well, what's been said by Mr Hames is that that breaches what my Lord said about falling between two stools in Re A. Now, of course, your Lordship knows what was meant, what your Lordship said in Re A, but I respectfully submit that what was meant in Re A was not what is being said on behalf of the mother in the present case. What I say about Re A, if I can find my notes, is in fact that the falling between two stools would be if one does what was done by, in the case of K, and knocks out the allegation at the first stage without either hearing oral evidence about it or taking it at its highest. If one says, for example, oh, well, I don't believe this and there's other evidence about it, one's effectively judging it without the wherewithal to judge it. Remember, this is an Article B13b, so it's important to be done properly. And one that is then falling between the two stools. One is neither hearing oral evidence and deciding the case on a full-scale contested basis, and neither is one taking the allegation at its highest. So in that situation, one is falling between the two stools. And I also submit that my Lord Justice Moylan expressed approval of compendious conclusions in Re W. That's Authorities Bundle 18. I probably needn't take you to it at this stage, but I do refer to that.
Just going on the brief, if you go to paragraph 124, which is where the judge concludes this section, again, what's he in sort of colloquial terms, what's he doing there?
Well, again, he is saying on any view of things, either because they never reached the threshold in the first place, or even if they did, there are sufficient protective measures. And one can tell that by looking back to see the way in which he approached it in detail in the paragraphs which precede paragraph 124. Can I just deal, while I think of it, of the criticism that the judge did not look at the individual allegations compendiously, and that there was some error there. I do ask, again rhetorically, if you look at the allegations compendiously, you're going to deal with protective measures, because you can only deal with protective measures by reference to each individual aspect of the allegation. And as I've said in our written submissions, 0 plus 0 can't equal something anyway. If something doesn't amount to an intolerable situation here because either it doesn't reach the threshold or because there are adequate protective measures for that matter, it can't, when added to something else, amount to an intolerable situation because that particular aspect has already been addressed. But I ask again, how on earth can one deal with protective measures if you look at the allegations compendiously, if there are, as there were here, 5 categories of allegations? Immigration status, I've already dealt with. Assistance, no doubt, they can continue to obtain. If the mother doesn't get the necessary immigration status, she can apply to the court, and one must presume, in the absence of evidence to the contrary, the court will deal with the matter in the best interest of the children. Basic necessities and financial provision, and again the judge dealt with that in detail. As before they left Spain, they're not going to be living in the lap of luxury, but as a stopgap solution until the mother approaches the court in Spain for some different solution, if that's what she seeks, and which she should have done in the first place. There are those sources of finance available to her. And one of them is a condition precedent for payment of it. But it's a carefully reasoned analysis. And again, in relation to all this, unless one can say, well, the judge wasn't entitled to come to that conclusion, and one can say why he wasn't entitled to come to that conclusion, that no judge was entitled to come to that conclusion. It's an evaluative exercise that he's going through, and this court isn't, with respect, entitled to interfere with that evaluative exercise, save on the well-known principles. But a very careful analysis, separation and risk of criminal proceedings, again, that's again dealt with by the judge. Abduction to Morocco, Mr Hames says he doesn't pursue that anyway. But what further matters is it said that require to be investigated? Where has the judge not addressed the asserted concerns in concrete terms? He's addressed them in detail, albeit the burden, as I submit, is on the mother to show why the identified protective measures do not ameliorate the matter sufficiently. Finally, in relation to the alternative point that the judge should have adjourned the matter for further investigations, well, what further investigations? We can proceed on the assumption that the mother hasn't got immigration status. Wouldn't have had it at that time anyway. Steps can be taken to try to get it. There's always open to her an application to court to relocate with the children, just as there is in England in similar circumstances. So for all the reasons set out by the judge, we say he didn't err in principle, that the conflation point is really a non-point here, as long as he is saying, well, if and insofar as it would amount to an intolerable situation without protective measures, it can be reduced below that. It will be a different kettle of fish if he was saying simply, I'm not satisfied that even without protective measures, this amounts to an intolerable situation. I'm not hearing oral evidence, so the question of protective measures doesn't arise. That, as we submit, is the legitimate criticism of the falling between two stools argument. So, my lords, my lady, looking at the time and knowing Mr Setright entitled to make some submissions, I'd better sit down unless there's any particular matter I can help with.
Thank you very much, Mr Turner. Mr Bennett. Mr Setright.
Yeah, please, my lords and my lady. Forgive me. We're grateful to be heard, my lords and my lady, and sitting in the front row is the Chief Executive Officer of the Unite, Ms Shalaby, and I thank my team who put together this pro bono intervention in about 3 working days. We hope we'll be forgiven if there are some rough edges to it, and we hope we're forgiven also for the non-provision of the hard copy bundle, but it might be interesting that in this case we're able to produce a clear, unequivocal, signed written consent from the Civil Appeals Office to us not putting hard copy bundles in. And that is the sort of thing which actually very seldom appears in an Article 13A case which is contested on a serious basis. Usually it's much, much more nuanced. Usually there is a considerable degree of orality, as the Irish put it, to the alleged consent or non-consent. We've tried, my lords and my lady, to give the court as much as we can in the skeleton. In particular, the international dimension, and plainly in the limited time I've got, I'm not going to plod through the skeleton. I'm going to give the court first such points as I think are helpful in supplement, and then to deal with any points that the court wants me to deal with. But Lord Justice Thorpe, who had such a formative influence on this Hague jurisdiction, used to have as one of his more acute pronouncements that the Hague Convention is an international convention without an international court to determine issues under it. And what one sees in the international, the smorgasbord of international cases that we presented this court with, is a diversity of approach. That diversity of approach is not surprising, given that there's no overarching international court. Equally, and rather curiously, it doesn't necessarily operate, as one might have thought, on a civil law, common law divide, where one might have thought the common law countries would say, well, oral evidence, that's the way to decide these things. And the civil law countries might say, well, it's all in the papers, why do we need to go beyond that? The Irish decision, which is at least subtly different from some of the English decisions, for example, gives an indicator that countries have developed in their own ways. Again, in the early days of the Hague Convention, which regrettably I can remember, it was often said that domestic judges shouldn't try to put glosses on the convention, which is a very good convention principle. But the activities of judges in this in this jurisdiction at 3 levels of court have indicated that there are massive glosses and interpretations on the Hague Child Abduction Convention. Are they more trouble than they're worth? Probably, though I would say this, they are not more trouble than they're worth. They do assist in the practical and hopefully consistent disposal of Hague business. Reunite's view at the present is, and of course they look at things from a slightly different standpoint, that there is a growing proliferation and expansion of Hague cases in terms of their length and complexity, and therefore the time that they take to resolve. If anything can be done within, of course, the overarching consideration that there must be fair and just determinations of the cases, that would be helpful. Equally, predictability is helpful. And that brings me to some comments, my lords and my lady. First, and dealing with it topic by topic, and I hope it's apparent to the court that we have ruthlessly focused on consent and have not chosen to stray into Article 13b, whatever the temptation, save in terms of the comparison between 13b and 13a. And with great respect to my learned friend, he may have misinterpreted what we say about the relative significance, and I'll come to that. But equally, we have been scrupulous in not going into the detail of this individual case, which probably won't help this court anyway, but isn't our business as we are completely neutral. But general submissions on consent. The first port of call, which we dealt with relatively lightly in our skeleton, because we say, with great respect to some recent decisions by puny judges, the position of the English court, as set out in successive judgments of the Court of appeal on two things: the circumstances in which one can, on the one hand, make findings without oral evidence, and on the other hand, will go in what is a discretion to look to oral evidence. Well, there's a consistent approach to that. And following on from that, there's a consistent approach, which is that oral evidence is permissible but by no means obligatory in some cases under the 1980 Hague Convention, and that for particular reasons, consent cases are those which may particularly lead to consideration of oral evidence. And we don't suggest to my lords and my lady that there's any real controversy about this at Court of Appeal level, and we don't suggest that it needs radical revision either. We extracted the Hague's own practice guide document, which we say with respect is an important document because it indicates such efforts as the Hague Secretariat or the Hague Convention can put to consistency. My learned friend, Mr. Turner, no doubt in the interests of saving time, was selective in the extracts that he read from paragraph 6.5.2. We've set out rather more than he read out in our skeleton. It will take me a time to read it out, so if I may, I won't.
Please don't.
And I will rather rely on the court to read it through in its entirety, but as a trade-off, I'll editorialise, and we say that what it says quite plainly is that there can be a recourse to oral evidence, and that in some circumstances it's advantageous, and recognising as they do, and Reunite puts a strong premium on it, the need for speed and an authentic summary process in the dispatch of Hague Convention child abduction cases. This document goes so far as to say that in some circumstances, hearing oral evidence can speed the process. It can be a pragmatic approach. But of course, we say, that depends on the degree of assiduity with which that oral evidence is controlled once admitted. And so we say that my lords and my lady, is a starting point. And it was interesting to see the so-called packing cases case, that's the REF, heard in 1991, a very unusual case. And my Lady Justice Andrews' point put to Mr. Turner, which was about the cart and the horse. Maybe the cart and the horse were inverted, most unusually in that case, inevitably. Those were very early days for the Hague Convention, and I was very much younger. But even then, it was plain that in some cases, oral evidence had to be considered. And I can say to the court, though I think Lord Justice Moylan will know it well, that in those days there was a very much more summary approach in numbers of the cases. Sometimes they were heard on the day of issue. Sometimes an ex-parte hearing at which the abducting parent attended turned into an immediate non-consensual hearing. That wouldn't be allowed today for all sorts of reasons, and it was all pre-Human Rights Act. But even then, I was able to identify that on the facts of the case, there might be a question as to whether oral evidence should be heard. So although I didn't want it for adversarial reasons, I raised it, and curiously, my then opponent said, well, I don't want it. And so the judge, Mr. Justice Johnson, not a judge known for being slow to determine a case, and rarely appealed successfully, said, fine, right, on we go. And the result was that, in effect, he wasn't offered oral evidence, and so he could determine what to do with the case. Technically, I suppose, Mr. Justice Johnson could have said, oh, no, Miss Rogers, no, Mr. Septright, this case takes oral evidence. That hasn't been discussed in this appeal, but I throw it in for what it is worth, because judicial intervention is a key, and I was reminded last year in the hearing of G&G, which was the asylum abduction case in the Supreme Court, by Lord Stevens, that in his view, child abduction cases are inquisitorial. And perhaps, though I tried to argue with him about that, but in the end deference won out, and it wasn't directly relevant, with due respect to him. But there is that aspect to case management. Case management is always an active thing, and determining how a case is fairly tried is also an active thing so far as a judge is concerned. If I go on down that road, I'll do myself out of more substantive submissions. But I wanted to go on next to look to see how the law developed. Re F, which wasn't a consent case, predated Re K, predated the Lord Justice Ward, and obviously the subsequent Lord Justice Peter Jackson decisions, the latter being Re G, on the ingredients of consent. So we have those to consider. And
I thought Re G paragraph 25 was common ground.
yes, well, it's common ground between the parties. Whether your lordships are happy with it, well, I hope your lordships are, because I think it is common ground generally. It sets the benchmark. And, my lords, if one looks at, without going into the individual cases, recent apparent diversions which might lead first instance judges to think that they take shortcuts or take a more draconian approach to the question of deciding whether or not there should be oral evidence, or shorter cuts to determining cases without oral evidence, the distinction, and it's the distinction which is that between Article 13A consent and other defences, including 13A, and other elements like habitual residence, and the explanation as to why it is that oral evidence is more frequently and appropriately taken in 13A than other matters is something that I can deal with very summarily, if that would help, and perhaps I should.
Well, to cut across you, isn't it my Lord Justice Moylan's point? It's a fact-finding and it's at the heart of the case.
Exactly, and that was the point which I believe, with great respect, Mr. Turner has slightly misinterpreted. We're saying 13B isn't that.
No.
Because of the sophisticated formulation in Re-E,
Yes.
the court doesn't have to fact-find. It simply takes facts as alleged. Equally, if the court was to do otherwise, it would impinge on the domestic jurisdiction of the requesting state. Article 13A is quite different. It specifically is an element of the convention. And what hasn't been mentioned, but again, Lord Justice Moylan will know all of this, is that there was a dispute resolved by Lord Justice Peter Jackson in G as to whether consent should be viewed as a defence under Article 13A or as an element under the root of the convention, the foundation, which is Article 3, by which not the defendant but the applicant has to demonstrate that the child was removed or retained from the other jurisdiction in breach of the rights of custody of the left behind parent. If there's a consent, of course, there's a strong and obvious argument that if the consent is proved, where was the breach of rights of custody? In which case, strongly arguably, you find the defence of consent made out, and there isn't a wrongful removal or retention. That is glossed over, and the practice these days is you treat it as a defence, and therefore it's dependent upon the discretion. But it has got that central element which makes it unique, and a self-contained element, and it's not ex post facto like acquiescence. I move on from there to whether it's satisfactory, how it is appropriate to look at the issue of whether to take oral evidence or not. The word necessary, but necessary combined with doing justice, is the formulation in effect of the practice direction, practice guidance. And if it was necessary out on its own, well, of course, it might be said, well, you don't actually have to have oral evidence, you've got a perfectly balanced case, and therefore the person on whom the burden of proof rests will fail if it's 50% and 50%. Does that do justice in a children's case? Well, we are inclined to say probably not, unless the court is absolutely driven to that. But the court may also ask itself, well, if that is the situation, will oral evidence assist in resolving it?
Well, would you dissent from the proposition that the judge should be saying, can I fairly determine this essential point of fact without hearing oral evidence? If I feel I can fairly do it, then I can do it. But in many cases, I might feel that it would be inappropriate for me to do so, and that will depend obviously on the circumstances of the particular case, whether you've got a lot of contemporaneous documents which might assist. The point I think that I put to Mr Turner that was concerning me was whether you could fairly say, well, it's so obvious that one side or the other is not telling the truth that I won't bother to test it.
If it's a question of one person's word on the orality against the other, entirely on the orality, that's a difficult situation. I might suggest a cop-out of putting in front of your ladyship's formulation, reminding myself that this is a Hague Convention case,
Yes.
in which oral evidence is the exceptional course to be avoided if it is possible to do so without infringing the interests of justice and a fair hearing proportionate to the fact that this is a Hague Convention case, and then go on with exactly what your ladyship's words
Well, I just
were.
wonder what that actually adds.
It's
The greatest respect. I mean, the judge is ex-hypothesised, sitting in a Hague Convention case, and knows that's what he or she is dealing with. He knows about the exigencies of time, and will factor into the question the fact that it needs to be done expeditiously. That's a given. The question is, can I fairly determine this crucial point, bearing in mind it's a Hague Convention case, without hearing?
My lady, I wouldn't dissent from that, provided the context is borne in mind.
Yes.
And the difficulty is that the judges of the family division have an absolutely colossal amount of work thrust upon them. And one of the areas that in these limited submissions I was going to come to is the practicality. And the difficulty, my lady, is how it all works.
Yeah.
The objective is to have hearings concluded start to finish in 6 weeks. The objective is to have, if possible, no more than one case management hearing. That's absolutely right. The difficulty in listing terms, practical difficulty, is that judicial continuity between the case management judge and the judge at trial is very, very difficult to achieve indeed, and relatively seldom is. The reason for that is that if the gap is going to be a gap of only 2 or 3 weeks, then for the clerk of the rules to manage to provide a judge who can do both is a practical near impossibility.
Does that matter so much if, as in the present case, I know you're taking a neutral stance, but here we've got a case where it just so happened you did get the same judge, but more to the point, at the case management hearing, the judge says, well, I'm going to case manage this in such a way that there will be scope for oral evidence if the trial judge so decides. And given that that is done, and there is a window there, albeit a limited one, for the oral evidence, then doesn't that obviate the problem? Doesn't that deal with the problem to an extent?
It does in this sense, that it keeps the court's options open. A price has to be paid for it in Hague Convention terms, which is that it has to be the longer time estimate that is provided if that is to happen. In this case, I said I wouldn't do this, but I'm going to. In this case, probably the difference was infinitesimal in terms of the time allowed. But in many cases, if you say the word oral evidence, that will add a day for reasons that are obvious.
But that's one of the things to be factored in, isn't it? I mean, I read Lady Butler Schloss's judgment, and I can't remember which letter of the alphabet it was, but we were shown that this morning. And she says that oral evidence on this issue is a jurisdiction to be exercised sparingly, but, I'm paraphrasing slightly, if both the parties are there and the issue is concise, what's the problem? And I mean, it might depend, mightn't it? If the taking of oral evidence was going to involve yet another adjournment, or it's a complex issue, or one party sends in a sick note, as litigants do if they don't want to bring things to a conclusion or something, that might be one thing. But is a trial judge entitled to say, well, all I want to hear is each of the two parties tested as to what happened on the 23rd of September, something, half an hour each side, no need for evidence in chief, right, Mr. Turner or whatever, your witness. That'd be wrong.
That's the way it's meant to work.
Yes.
That's the way that judges down the years have said consistently oral evidence should be approached. One looks in the judgment of Lord Justice Thorpe in Kay and sees that it went wrong in that case and the evidence proliferated and an additional witness was allowed to give evidence and the evidence rambled over a wide range of things. We say, with great respect, that there needs to be, notwithstanding the high demands on judges and indeed on the parties' representatives, there needs to be close definition of the evidence and the issues, and a judge needs to be able to look, have time to read, and to say, well, actually the key to this case, let's suppose there are 279 pages of WhatsApp documents. The key is actually the interchange on pages 143 and 144, and I want to look into that because there are gaps, and Lord Justice Peter Jackson said it's partly filling in the gaps. I want to look at that. I will hear oral evidence on that, but that oral evidence will be confined to questions about what was happening which led to that interchange and what you, Parent X, thought about it, bearing in mind that, as my lords and my lady will have seen, Lord Justice Peter Jackson in his summary, in paragraph 25, recognises that there is an objective and a subjective element, which makes it perhaps peculiarly sensitive in some cases to being better resolved by some oral evidence. So yes, my lord is quite right. What does tend to happen, and what Reunite is concerned about, is that notwithstanding that it is 11 years on from Lord Justice Thorpe's judgment in Kay, there are still cases where oral evidence is quite rightly permitted, but it goes out of control.
Yes.
And that's not because anyone wants it to go out of control. It just does, probably because there hasn't been enough time to read, probably because the evidence hasn't been fully and properly filed. And there's a trade-off sometimes between preparation and taking time over case management. But my Lord is also right that if matters are kept open to the final hearing, there is the discretion as to deal with it on the papers that are there and the arguments that are there at that time. Counsel of perfection is that it should be possible to achieve that a little bit earlier and therefore to have a very accurate and minimum time estimate. But it might be hard to see how that's achievable in practical circumstances at the moment. I'm not going to raise what's in the draft replacement practice guide, not least because I don't think I will be able to remember the detail of it with accuracy. But if any thought could be given to refinement, if it is postponed until after the judgment in this case, it might be possible for there to be guidance. Of course, this court will probably give guidance, which will be very useful for all puny judges. But practitioners and judges benefit from certainty, as to litigants. One matter that, of course, has changed and changed radically is the Lady Justice Butler-Sloss case, which was re-F in 1990.
Before video evidence.
Was before video evidence. What used to happen was that if the judge said, well, there may be a need for oral evidence, I can't say, that's up to the trial judge. People like me would say, well, can we have an order that the court directs that the father must attend to give against the possibility of giving oral evidence, and that the costs thereof are a reasonable disbursement on his public funds. That was an Australian case, and big stuff that. But nowadays it's easy post-lockdown to do it by video, so perhaps that's not so big a deal. My lords, I've been half an hour, but half an hour, although allowed 45 minutes, it's still half an hour at 4:15.
We're even more grateful to you than we would otherwise have been.
But
Any?
There's a but.
But. Yes.
Can I turn to those in front of me to see if I've missed it?
Of course.
I'm told I haven't.
Thank you very much, Mr. Setright. Yes, Mr. Hames.
My lords, my lady, I can be very quick. I don't dissent from anything that you've heard from my own friend, Mr. Setright. I just add as perhaps a gloss to what he said in respect to my submissions about protective measures, without wishing to open a can of worms. This court may well consider that there is an inquisitorial element in the consideration of Article 13b cases in general, but in particular in respect of protective measures. It may simply be a matter of active case management as to what information the court needs. But as the judgment of Lord Justice Henderson suggests, the court has got to look at the situation from the child's perspective on the ground as to whether the protective measures will do what it says on the tin, protect the child from the risk. Insofar as the discretion as to whether to have oral evidence is concerned, I'm not going to add to the general submissions that you've just heard, but simply to observe that in this case, if my lords, and this is the only document I'm going to take my lords and my lady to, it's simply the mother's statement at page 123, where you will see the ambit of the dispute in respect of consent. And whilst doing this, I'm going to just quickly deal with some of the points that my lady and my Lord Justice Bean has raised about the whole consent issue. It's about 1.5 pages of essentially oral assertion. And that's it. And with active case management, that needn't take very long at all in my submission. Certainly not when weighed against the need in every case, including Hague Convention cases, whatever the summary or the imperative to be summary is concerned, it's still got to be dealt with justly, fairly, as well as expeditiously. And I can't but resist us to remind the court of what the mother's case is in really two aspects. Paragraph 18, we spoke about moving to England after his visa was refused, and he said I could still go, and told me to take the children to England. And then at paragraph 19, once the children were returned to us from foster care, the father told me that I should go to England because if I did not, they'd be taken into care again. He said this on multiple occasions. And then there's the telephone incident. It's tried that on cross-examination that may be proved to be may be shown to be a pack of lies. On the other hand, the mother may come through with flying colours. It needn't be a long, drawn-out, complex process. There's not going to be reference, self-evidently, to lots and lots and lots of pages in bundles, looking up small points in social media messages and the like. I won't repeat what I said before. One just final correction. It may have been a slip in of the tongue from Mr Turner, Queen's Counsel, but in Re C, Sir Jonathan Cohen did not refuse to hear all evidence. He simply wasn't asked. I think that's clear from paragraph 59. Unless I can assist my lady or my lords further.
Thank you very much, Mr Haynes. I'm very grateful to all.
My Lord, while we're dealing with corrections, this is not argument, it's just a correction in my skeleton argument. There's a wrong citation. In paragraph 53, the Ray W case that should have been referred to there actually has a citation of 2017 EWCA Civ 2152.
And is it 2019 FAM 125 or not?
Yes.
Yes, good. Thank you very
It's
much.
a different case.
Well, that's a very
copied over,
uncontentious note on which to end. Thank you all very much for your assistance, both orally and in writing. We will, of course, reserve judgment, hopefully not for too long. The draft will be sent out in the usual way, as I'm sure everybody in court knows, not for re-argument, but just for correction of typos and manifest errors of dates and so forth prior to hand down. I hope all parties have supplied either the court office or the clerk to my Lord Justice Moylan, or both, with email addresses at which preferably two people in each legal team can be contacted during the vacation for the purpose of those corrections. Thank you all very much indeed.